Okay, we're going to go ahead and get started. I know that people are likely to trickle in, but just welcome to the people who are already on. Hi, Allison, Aloha Kikoa, KLM, Raylene. We're so excited to have you all here, and thank you for spending the time this evening. And also, thanks to people who might be streaming it later. We are going to post this on our NHLC website, and we'll send a link to people who registered over email. So whenever you are seeing this, just aloha. Thank you so much for spending this time with NHLC. It is a full program, and so I'm going to go ahead and get started. So my name is Makalika Naholova'a. I'm the executive director at Native Hawaiian Legal Corporation, and my kuleana tonight is to do the intro and also go over just a little bit of housekeeping before we really let the star of tonight's show, Henderson Hui Hui, and our director of litigation, Kawila Copper, talk about this really fascinating and interesting topic. So just to get us started, wanted to set the groundwork by letting everyone know that this information tonight is intended to be legal information for general educational purposes. It's not legal advice. So please contact our office if you have a specific legal issue that you need help with. So it's very possible that as you watch this, you start to realize that you might have a legal issue and need some help. And if that happens, please don't hesitate to call us and we'll provide more information about how to do that. Rules and law referenced in this webinar can change. So, the law is changing all the time. A lot of the topics we're going to talk about today are pretty mature. And so I wouldn't say that there's a ton of change day to day, but it can change. So please contact NHLC to confirm the accuracy of this content before you copy or reproduce it. We're also happy to share. We just want to make sure that if anyone's taking this and reusing it in other places, that they check with us that it continues to be accurate. More housekeeping. So the presentation is being recorded and we'll post it on the web and on our YouTube channel, like I said. For that reason, we're going to take questions through the Q&A feature. So the Q&A feature is at the top of your screen. You should see a number of different icons, and there's one that looks like a chat bubble and it says Q&A under it. So if you submit any questions that you have at any time during the presentation using that feature, we will make sure that at the end, we ask as many of those questions as we can. And, we expect that we can go through at least 20 minutes of questions. If you're having any trouble with the tool and you can't find the Q&A feature, you can also just email us at info@nhlchi.org. And we will be monitoring that email address throughout the presentation, and we'll make sure those questions get captured as well. And then finally, if your question's not answered, please don't hesitate to call us. We are open Monday through Friday, and Henderson will provide more info with our phone number and things at the end. If you like this presentation and you think that it would be helpful to have it in a private setting, maybe with your Homestead Association or some other hui that you're a part of, we are also happy to do as many of those as we can accommodate. And, we did one of these a couple of weeks ago on successorship. We haven't been actually inundated with requests, so there's good reason to believe that if you want a private session and you ask, that we're going to be able to make that happen. So all of these are ways to get that content and your questions answered. Now I'd like to introduce our presenters. So you can see their pictures on the slide, but I think you can also see their pictures on the screen. So we've got, and I think Kawila did us the favor of wearing the same shirt, so that's helpful. So Kawila is our director of litigation at NHLC. He has been with the firm for more than a decade, has dedicated his career to Native Hawaiian rights law. He's a graduate of Kamehameha Schools and also the UH Richardson School of Law. And he is going to be co-piloting this presentation with Henderson. Henderson is also a graduate of Kamehameha Schools and UH Richardson School of Law. He started his legal practice 2 years ago here at NHLC. He's been with us as also a part of a program run by an organization called Equal Justice Works. So he's here as a special fellow with Native Hawaiian Legal Corporation, and the focus of his fellowship has been homesteader needs. So Henderson is a fourth generation member of a family that lives on a homestead in Waimanalo. These issues are issues that are near and dear to his heart, and we're really excited for this presentation because he is near the end of his 2-year fellowship with us, and this presentation and the one that he did a couple of weeks ago on successorship are really the culmination of his research and work in these areas. And we're just all very excited that he has the chance to be here with all of you sharing his mana'o and ike in this space. So with that, Henderson, I will turn off my camera and pass it to you.
Thank you, Makalika, for that introduction. I will say, though, I want to clarify, I'm a proud grad of Kailua High School, so a different blue and white. Now, again, though, mahalo for that introduction, and aloha to everybody that is joining us here tonight or viewing this later on the web. Before we get started, I just want to give a brief introduction of the Native Hawaiian Legal Corporation. Now, NHLC is a 48-year-old independent nonprofit law firm with a small but mighty team of 6 attorneys. Now, NHLC is committed to supporting homesteaders to ensure that ensure protection of their rights and the accountability of the Department of Hawaiian Homelands to its beneficiaries. Now, NHLC provides legal services in DHHL and other state land trust entitlements for Native Hawaiians. And the services that our office generally provides are legal representation in court or administrative hearings or negotiations, and counsel and advice. You can contact us by phone, email, or our website for help. And the contact information will be at the end of this presentation. Or for more information on our history and the work that we do, please go to our website. Now, before we get started in this webinar, I want to acknowledge that the cancellation of a homestead lease is a very heavy topic, and it's not something to be taken lightly. And as a homesteader myself, it is something that I would never wish for any family, because I know that a homestead can be so important for creating generational stability and bringing us back to the Aina. Now, lease cancellation can be a very overwhelming situation. And today we're going to talk about what to do if DHHL tries to cancel your lease and how you can avoid it. Specifically, we'll talk about how often the department seeks to cancel leases, the reasons they might do so, an overview of the process, some examples of avoiding cancellation, and how and when to request legal services from the Native Hawaiian Legal Corporation. Now, how often does the department seek to cancel leases? DHHL, they don't publish how often they tell lessees that their leases might be canceled. Now, the department claims that in the past, its requests to cancel a lease were as high as 30 or so in the span of about 5 years. And we've noticed that there have been fewer requests to cancel a lease during the pandemic. But even then, we feel that if there's one lease cancellation, that's one too many. What we have seen this year is 7 requests to cancel a lease. And I do want to point out, though, that those are likely related to a lack of a qualified successor for those leases. But unlike successorship, which affects every lessee, hopefully lease cancellation is not an issue that will come up for most families, but we do acknowledge that it does. And again, one cancellation is one too many. Now, what reasons could DHHL use to start this lease cancellation process? Now, DHHL is authorized by the Hawaiian Homes Commission Act to cancel a lease if they believe there is a violation, or that the lessee violated either the law or a specific term in their lease. But even if there is a violation of either of these, if the department wants to cancel a lease, the lessee must be given a hearing. And we'll talk a little bit more about that later on in the webinar. Now, the law and homestead leases, they lay out a number of different requirements for lessees. And the department can start the lease cancellation process when they think there is a violation. And we don't agree that cancellation is always the way to solve lease violations, but we'll now take a look at 5 common examples of things that might lead to a lease cancellation. So the first would be DHHL believing that the lessee failed to maintain their property. So that could mean that they think there were unpermitted structures on the homestead, or that the homestead, they could say the homestead wasn't kept in a clean and orderly manner, or they could say that there was no insurance for the homestead. And now sometimes the lessee might not be able to get insurance because the property might not be insurable. And if that is the case, there are different resources such as rehabilitation loans or organizations in the community that do help homesteaders make necessary repairs for their homestead. Now, the next reason the department might use is they might say that the lessee improperly used the homestead. So for this, the department might say that if it is a residential lease, they might say that the lessee was required to live on the property full time. And that is a general lease requirement. But if there is some reason that the lessee is unable to live on the property full time, they can ask the department for permission to be off of the property for extended periods of times. Now, if the lease is an agricultural or pastoral lease, the lessee has to live on the same island as their homestead, because with those leases, sometimes there isn't a house on that lot. The department will also require that a lessee with those leases have a farm plan or cultivate a certain amount of the lot. In these cases, with agricultural pastoral leases, it all really depends on what the lease says, because usually those are they have more specific requirements, and it depends on each situation. Now, third, some homesteads have in their leases a mandatory homestead association that acts like a homeowners association. So the department might first establish a set of certain rules that are specific to that homestead community. And these rules can be changed by the homestead association as time goes on. An example of that might be the newer Kapolei homesteads. Now, the association can enforce these rules as well as lease conditions through imposing fines, starting private legal action, and they can even ask the Hawaiian Homes Commission to start the lease cancellation process. Now, from our experience, though, this is something that rarely happens. And if it did, it would be the commission that would be the decision maker. It wouldn't be the association, because only the commission can cancel a lease. Now, fourth, DHHL might say there was illegal activity taking place on the homestead property. And on this one, I want to point out that sometimes a lessee can be held responsible for non-lessees' illegal activity on the property. And fifth, DHHL might believe that the lessee has missed payments that are required by their lease. Now, this one is a little more complicated, and there are other things to talk about it, so we'll look at it in a little more detail. Now, generally, there are three main financial obligations tied to a homestead lease. The first is that there is the lease rent, and that is for the land itself. It's not for the house, and that rent is $1 per year. And so because leases can be extended for a total of 199 years, the total lease rent is $199. And oftentimes what people do is they pay the whole entire lease rent at once so that they don't have to worry about it in the future. Now, the other thing is that the Hawaiian Homes Commission Act does allow for counties to tax a homestead. And so it depends on each county what that tax will be. And so paying the taxes is a requirement of lessees. Now, for Oahu residential leases, it's a flat rate of $300, and counties do have the authority to increase or decrease the taxes as they see fit. So when a homestead lease is first awarded, the homestead isn't taxed by law for the first 7 years. But if it's been more than 7 years and you haven't received the tax bill, you should contact your county tax office right away to get that straightened out so that there aren't any issues. For this tax issue, it's important to talk about because if you do fall behind, one, you should contact your county tax office to work out a payment plan. But for homestead properties with back taxes, what happens is the department will pay the property taxes and treat that payment as a loan to the lessee that the lessee must then pay off in order to avoid lease cancellation. And then third, the third financial reason for cancellation is if the department believes that a lessee hasn't kept up on their mortgage. So issues on mortgage payments are a lot more common than the other two requirements. So I want to discuss mortgages a little more in depth because it can be a bit of a complex issue or a complex process. So because mortgages are a more common issue area, and we have gotten a lot of feedback on some confusion with the different people or parties that are involved in a homestead mortgage. So what I want to do now is take a few minutes to look at mortgages and help you understand how they work with homestead properties. But if you are having issues with your mortgage or have questions, it's advisable that you contact a financial counselor to discuss your issue. So what you see here are the common players in a mortgage. And we'll go over the mortgage process in the next few slides. And I do want to point out that it's this is the general process, so it may not be the same in every case. But what you have here usually is the lessee, a bank, a mortgage insurer, such as the United States Housing and Urban Development, or HUD, or the United States Veterans Affairs. You've got the Department of Hawaiian Homelands and the Hawaiian Homes Commission. So the Homestead Act, it does allow for homesteaders to mortgage their interest in the lease, so the lease itself, not the land. And a mortgage might be needed by a homesteader to purchase an existing home or to make improvements or take out the equity on the home. So the first step is that the lessee goes to a bank for a mortgage, and the Hawaiian Homes Commission Act requires that the mortgage be insured by either a federal agency, such as HUD, or the VA, or a private mortgage insurer. So basically, the bank will go to that insurer to get the mortgage guaranteed. And that's done so that if the mortgage goes into default, the land of the homestead won't be lost to the bank for closing and selling the homestead. So then the lender goes to DHHL, which puts together a request to approve that mortgage, and then the commission will approve that mortgage request. So when a homestead mortgage is issued, the lessee has some certain responsibilities, and one of those is to make their monthly mortgage payments on time. So if a lessee doesn't pay, then the mortgage insurer, such as HUD, they are the ones that usually have to pay the bank. And if the mortgage insurer has to take on that mortgage and pay the bank, then what happens is the department has to take over that mortgage and pay the mortgage insurer. And so the way that DHHL does this is by either becoming the lender and collecting payments from the lessee, or canceling the lease and reawarding it to a new lessee. So what happens when a lessee with a private loan is not making or unable to make their payments? So if the bank believes that the mortgage is delinquent and that payments aren't being made, they should contact the lessee to either collect payment or discuss payment options such as a payment plan or refinancing. If the lessee does not pay and the mortgage then defaults, then as I said, the insurer is required to take over that loan, and then the department takes over that loan and pays the insurer. And as I mentioned, just again to reiterate, the department will pay that loan by either becoming the lender and collecting payments from the lessee, or rewarding the lease by canceling it and rewarding it to a new lessee. And again, this is just one example of what the situation might look like, and it may vary with different leases and mortgages. So this is what DHHL will send a lessee if they believe that their mortgage is in default. This letter or this notice should say that, or might say, that the department has taken over the loan, and so if you are having issues with your mortgage, you should be on the lookout for this letter, because this means that lease cancellation, it's going to start. Now, this notice may also say that the department is willing to work with the lessee to avoid lease cancellation. And so since the department has taken over that mortgage or that loan, they can become the lessee's new lender, and the lessee should be able to make payments to the department directly. So should you ever receive this notice, this letter, please do not hesitate to contact the department or an attorney to see if you can work out a solution to keep your lease. Now, what should a lessee do if they need help with their mortgage payments? The first thing I would say is to talk to their lender, to talk to your lender, or if it's the department that's the lender, talk to them, as there may be certain options available, such as working out a payment plan or refinancing the mortgage. Another option to explore is talking to a financial counselor or seeking out other community resources. So there are a number of different organizations that do provide financial counseling, and they may also offer mortgage payment assistance, emergency loans, and sometimes grants that can help lessees having trouble with their mortgage. So these are services that a lawyer generally isn't able to offer. But a lessee should still also consider talking to a lawyer, because what a lawyer can do is to help and make sure that DHHL is following the rules in this process. And the last piece of advice is it's important that the lessee check their mail, because they will receive these notices about the lease or the mortgage by mail. And so we have seen in some situations, unfortunately, where lessees they didn't check their mail and they might have missed a notice, and then that might have made things a little more difficult for them in the lease cancellation process. So the takeaway from all of that is that the department may try to cancel a homestead lease for a number of different reasons.
Yeah, thanks, Henderson. He just talked about five of, many situations where the department could choose to start a lease cancellation process. And often in those cases, there could be legal defenses. But we also believe that if the lessee is willing to fix any issues that really are present, well, then the commission and the department really should bend over backwards to accommodate them because of their trust duties to their beneficiaries. And I think we're going to cover settlement later, but it's something to flag that, yes, unfortunately, leases are scheduled for cancellation. We would say far too often. Because there is an argument that should be made that these cancellations should rarely happen. But if a lessee believes that, hey, there is an issue that I can try and fix, we think that the department should let them do that and not cancel the lease. And we've seen that work successfully in some cases. So just something to flag. I know we'll touch on it later.
Exactly. Thank you for that, Koila. So next, what we'll talk about is the hearing process that I mentioned earlier. So what is a contested case hearing? A contested case hearing is like a trial, but it's less formal. And it's the hearing that's used to make a decision on whether or not to cancel a lease. Now, the Hawaiian Homes Commission, or someone they choose and appoints as a hearing officer, they act like the judge and they take evidence in the hearing. Now, in a lease cancellation process, the Department of Hawaiian Homelands and the Hawaiian Homes Commission, those are treated as two separate entities. And so what that means, on one side, there is the Department of Hawaiian Homelands who makes the argument to cancel the lease. And then on the other side is the lessee who will say why the lease shouldn't be canceled. So at the
If I
end,
could
Mhm.
add something, Henderson, that's a really good breakdown. And these contested case hearings actually happen not just for DHHL, but for a
Mhm.
number of different state agencies. And its history goes back to, trying to come up with a process that decides really important issues, but that are still accessible to the community. So, there are formal. There's no suits. It's not in a courthouse. Um, really, it's made for anyone to be able to go and represent their interests. That said, like Henderson has flagged, these are still very important proceedings. These hearings, they are like a trial, and so while you may definitely be capable to go without an attorney, it is something to contact an attorney about and decide if representation is something that's needed.
Exactly. These hearings can be complicated or sometimes intimidating, even though they are less formal. So what we want to do now is take a look at this process of what a contested case hearing looks like. So first, DHHL should notify the lessee of a lease violation, as well as their intention to request to cancel the lease. Second, DHHL will ask the Hawaiian Homes Commission for a hearing to have that lease canceled. The decision to have a hearing will be made at the Commission's regular monthly Commission meetings. So third, the Commission will then approve that request at their monthly meetings. Fourth, DHHL should send the lessee a notice of hearing. The first notice that we talked about earlier, that said that the lease could be canceled. This notice is saying that there will be a hearing to decide if the lease should be canceled. Now, either a hearing officer or the full commission will hear the contested case hearing. And there is a time period for a lessee to file an objection to the assigned hearing officer if one's appointed, but really that's something that's rarely needed. And so 5, an optional step is that the hearing officer may hold pre-hearing conferences. And what that is a formal on-the-record meeting with DHHL and the hearing officer. And pre-hearing conferences are used to set deadlines or figure out certain logistics for the hearing, such as deadlines to submit a list of exhibits and witnesses to be used, or how the hearing will go. And so really how the hearing goes in that sort of regard is it kind of depends on the hearing officer, how they want to handle the hearing. And so that also says that like they aren't required to hold these pre-hearing conferences, but they may choose to do so. But before, and Koila kind of touched on this, before a contested case hearing is held, both the lessee and DHHL can work out an agreement or a settlement to avoid canceling the lease. And as a reminder, at all times during the process, the lessee can have legal counsel. So we do recommend hiring an attorney if you can. Now this slide is important. This is what a lessee should look out for if the department has said that they're going to start the lease cancellation process. This is a notice for the hearing, and it's sent by certified mail, so that somebody needs to sign it to receive it. This notice is something that the department is legally required to send to the lessee to start this cancellation process. So the notice should have the date, time, and place of the hearing. And generally the location is on the lessee's island, but the law does allow for hearings to be held over Zoom. And the hearing, the notice will be sent at least 15 days before the hearing. So if you do receive this notice, it's important to seek an attorney or to talk to an attorney?
You know, these are really important because it's something that the department has to do. That, you know, a lease cannot be canceled unless you get one of these. So not only is it, you know, if you see one, okay, yeah, we need to act quickly on that. It's also if you don't see one, but yet you get other paperwork or hear that your lease might be canceled, because the law requires due process that you know about things that are going on related to your property interests and any land you have. So that's why not only are these important to act on if you see it, but also if you don't see one and you're in a hearing.
Exactly. Now returning back to the lease cancellation process. So step 6, the actual contested case hearing is held. During the hearing, both the department and the lessee can submit evidence to the hearing officer. The hearing could be short or it could take a couple days. So again, both sides during this whole process can talk about and try to work out an agreement to avoid lease cancellation before and during the hearing process. Because the hearing can be a little complicated, it's recommended that you do talk to an attorney about it, or hire one if you're able to. So what happens the day of the contested case hearing? Again, the hearing is the trial that determines if the lease should be canceled or not. So it's very important to attend and present your side of the story to create a record of information for the commission and possibly a court to consider. Now, during the hearing, the lessee has the right to examine all documents or exhibits that the department wants to use. The lessee also has the right to bring their own witnesses and establish their own facts and circumstances through either testimony or submitting documents. And they also have the right to question or refute any testimony or evidence that the department gives.
You know, I think there's something that could be said that, hey, the having to go through this process is really unfair to the lessee. And I think in a way, on one hand, that's absolutely true. And that's why we're saying that, you know, lease cancellations should only be used in the most rarest of occasions because it is a lot. It's a lot for anyone to do. But it's also a good thing that you are able to do all of these steps, because what it means is that the state cannot take away your lease unless you have the ability to provide evidence. You can call in witnesses, you can get documents, you can have an attorney if you want, but it's not required. You can file paperwork, so you can appeal. And so, you know, it's a lot, but it is really important because if you didn't have that opportunity, then there wouldn't be as effective of a way to stop the cancellation of your lease.
Yeah, that's a really good point. So thank you for that, Kulīla. And just a few more points on the contested case hearing day. Should a lessee choose to go on without an attorney, there's just a few things that I think are important just to be aware of so that you understand and what it will look like and you can expect certain things so that they don't surprise you. First would be that the lessee should arrive or if on Zoom, log in early to let the department know that they're present. Because if a lessee is not present, the hearing will still go on without them. Now, if the lease is being canceled due to a loan delinquency or a loan issue, a loan officer may try to meet with the lessee to settle the case beforehand by coming up with a payment plan. Now, at the hearing, there's usually a hearing officer if it's not the full commission, a DHHL staff person who takes notes, a DHHL staff person that argues for lease cancellation, and if there's a mortgage involved, a loan officer. So the hearing will start, the parties will introduce themselves, and then they both will make opening statements. and then they can start introducing their own evidence. So after that, it closes with closing statements, and then a decision is made later. And with that, there are some other deadlines that will or might come up after the hearing closes, that the lessee can use as an opportunity to argue against lease cancellation. So the evidence presented in the contested case hearing is the only information that the Hawaiian Homes Commission can consider when it decides whether to cancel the lease. If a later appeal is filed, the only evidence that the court can look at is the evidence that was brought into the hearing. So it's important to be sure to include helpful evidence to show why the lease shouldn't be canceled. And some helpful evidence, such as testimony or witnesses or exhibits, can be used to show that no violation happened and that the department is actually mistaken or wrong that a violation happened. Evidence can also be used to show that the lessee is making good faith efforts to fix the violation or that the violation is resolved. So that might look like showing documents to that the property has been repaired and the lessee is either working or has obtained insurance, or that they stopped any illegal activity that was happening, or if it's a mortgage issue, that they resumed payments or have been seeking financial counseling. So as we've mentioned throughout this process, at any point, either before the hearing or after or during the hearing, the department and the lessee can try to settle and avoid lease cancellation. Now, settlement, it might not happen in every case, but it does happen with some of the cases that NHLC has been involved in. Now, settlements could be making repairs to the property to get insurance, or again, stopping certain activity, or coming up with a financial plan.
Yeah, it's something to add when we definitely acknowledge that, hey, there could be a judgment over whether leases should be put into this process in the first place, right? And we're not saying that it's necessarily the right way to get things fixed. But once a lease is in a cancellation proceeding, like, that's all hands on deck. Let's stop that, because not as one lease canceled is too many. And this is just one of those tools where again, like we mentioned earlier, if your lease was up for cancellation because there's, let's say, no insurance for the property, one way I think that you'd have a very good argument, if not to settle, but at least to win the contested case hearing, would be to get that insurance, right? Again, not saying that that's the right or wrong way that things should be done, but it could be a way to get out of the lease cancellation. And once someone is in this contested case hearing, it's adversarial. It feels like you're fighting, and it's hard to just put things aside. But again, not saying it's something you have to do, but some people might not be aware that it's an option. And it's an option that we've seen work for families to keep them on their lease.
Exactly, and it's an option that sometimes we pursue. Now, returning back to the cancellation process, number 7, after the close of the hearing, the commission will make a decision. When the hearing officer or the commission makes their final decision, the lessee still has some opportunities to argue against canceling the lease. And then number 8, when the commission makes its final decision, they have to let the lessee know, usually by mail, about the decision. So another very important notice: after that contested case hearing, the lessee should look out for this notice. And what this is, it's the commission's final decision order canceling the lease. And this notice is critical because once the commission mails it out to the lessee, the clock starts ticking on the time to appeal or do anything about that decision.
Yeah, um, if you're in a lease cancellation, this is one of the more important things that you'll receive. And unfortunately, right now, the law only requires that it's delivered to you by mail and not even certified mail, just regular US mail. And that's a problem because things can happen to mail. Um, and this is such an important document, as Henderson will cover, because once this is sent to you, not when you get it, but once this is sent to you, it starts some deadlines that are really important to meet to keep trying to fight this. So definitely something to look out for if you're in a contested case hearing, because unfortunately the law just says they have to mail it to you. So it's something that anyone could miss.
Mhm. And if this is something that you do end up receiving, um, it is advisable to talk to an attorney as soon as possible if you're thinking about challenging the cancellation. So when can a lessee appeal or challenge a lease cancellation? A lessee is able to appeal a decision and order canceling their lease after the commission mails that final decision. Now, the law does have short and strict deadlines. And so the lessee has 10 days from the date that the commission mails out that order to ask them to reconsider the decision. They also have 30 days from the date that the commission mails out that order to appeal it to the circuit court. And so another thing to remember is that any appeal is limited to what's introduced in the hearing. So if it wasn't brought into the hearing, it can't be looked at or considered by the courts. And again, I just want to emphasize that even if a lessee did not have an attorney during the hearing process, they still are able to contact an attorney to discuss the possibility of an appeal. So again, should you get one of these notices, should contact an attorney as soon as possible because there are these deadlines.
Yeah, there was a really bad court decision from our appeals courts called the Tanaka case. This is from the early 2000s, 2004. And that case says that if you miss those deadlines, that there's nothing that the lessee could do to get their lease back. And not only that, there's nothing that the department could do to give the lease back. Now, that's what the court said. For now, that case is law. It's something we don't agree with. We have 2 ongoing cases that are trying to poke holes in that law. And these are situations where courts would say too late, but we believe that that should not be the rule and there should be ways around those deadlines. But it's still important to flag that it's a whole different type of challenge if those deadlines, if something is not filed by those deadlines because of that really bad case.
Mm-hmm.
There could still be something you can do, and definitely leases are something that should be fought for. Henderson is right, probably a good situation to contact an attorney if you have not already. But again, something to look out for, that those deadlines do change, the nature of your case.
Mm-hmm. Yeah, so that notice is really important because of those deadlines. Now we've gone over the steps in the lease cancellation process, as well as some ways that a lessee can work towards avoiding having their lease being canceled. But if lease cancellation for whatever reason was not avoidable, the department will send a notice to the lessee asking them to vacate and requiring the lessee or the former lessee to move. Now, if the lessee refuses to move, the department can use the help of the district courts to use ejectment proceedings. And so these ejectment cases, those go to the district courts, which generally will say by law they cannot decide if the department shouldn't have canceled that lease. And so again, that appeal, that 30-day deadline is really important. because any appeals of a cancellation of a lease need to go to the circuit courts. And if it wasn't appealed within that 30-day deadline, then generally the courts, they won't be able to look at the lease issue. Now, if the department wins in this ejectment proceedings, the court will grant them what is called a writ of possession. And that allows the department to be able to ask law enforcement, so the sheriff's deputies, to make sure that the former lessee moves out. And the DHHL can also ask the district court to order the former lessee to pay any of their court costs and fees if they win. But so if the lease is canceled and an appeal wasn't able to be done, so long as the lessee moves, the property should be appraised to pay out what are called net proceeds of the improvements of the property. And as I'll explain the next slide, the net proceeds process usually starts after the lessee moves out. So if a lease is canceled, DHHL should pay the former lessee the net proceeds of the homestead. And so what are net proceeds? Net proceeds are the appraised value of the improvement, so the house and any other permanent structure, and if applicable, crops on the homestead minus any debt that might be owed to DHHL. So if there's an existing mortgage or real property taxes. And so there are a couple steps here, but really the hope is to avoid getting to this point, because we understand and know that the value of a lease in providing generational stability is worth much more than what might be paid out in terms of net proceeds. So the lessee does have a few options that they can choose from in appraising the homestead. First, they can let the department hire and pay for a disinterested appraiser, or the lessee and the department can choose and equally pay for an appraiser. And the third option is that they both can hire their own appraiser. Now these net proceeds payments, again, they're generally made after the homestead is awarded to a new lessee. So I guess one piece of advice would be, if a lessee reaches this point in the process, one advice or thought would be to basically try to make it so that they can at least walk away from this terrible situation with some funds. So that might mean cleaning up and packing up the homestead, because if there are any belongings that are left, the department will charge or try to charge the former lessee for that cleanup. And if possible, try to do any light maintenance that could help to bring up the appraised value. And if there is a mortgage that was on the property, on the homestead, interest and fees will continue to accrue until the net proceeds process is completed. So with that, the longer the lessee stays, the less money that they'll be able to get. So when should a lessee see an attorney in lease cancellation? I would say as soon as you have any reason to believe that your lease is at risk, you should talk to an attorney, because there are many steps in the process where an attorney can actively work towards defending against lease cancellation. But a lessee can also contact an attorney if they receive a notice of a lease violation, or they receive a notice for a contested case hearing. And again, we highly recommend that a lessee facing lease cancellation retain an attorney for that contested case hearing. But even if the time to appeal a decision canceling a lease has already passed, the lessee may face those ejectment proceedings. They can still contact an attorney as well, because it may be possible to negotiate an extension of time to wrap up their affairs and avoid that writ of possession. But a lessee can also contact an attorney if they have questions about the department's administrative rules, because those can be confusing and sometimes difficult to navigate. But the important thing is if a lessee receives a decision canceling a lease, they can reach out to an attorney if they want to talk about appealing a lease cancellation. And they should do so as soon as possible because of that 30-day deadline we talked about.
And you know, this workshop today and presentation focuses on contested case hearings, but you know, sometimes there could be lawsuits that you can start that's separate from a contested case hearing that could help to keep a lease. So it's another reason why consulting with an attorney is important, because contested case hearings are important. It's something that you have to have offered to you, but there might also be other things, other legal steps you can take to protect your lease.
Exactly. So now in closing, I want to say that NHLC, the Native Hawaiian Legal Corporation, is one legal resource that is available for lessees who are facing lease cancellation or having lease issues. So I'd like to close in talking about how to request legal services from the Native Hawaiian Legal Corporation. And that starts with your initial contact to our office, either by phone at 808-521-2302 or online at our website at www.nativehawaiianlegalcorp.org/contact. So after your initial contact, our intake staff, who are very, very friendly, will follow up to gather some brief initial information from you. And that usually includes your name, your date of birth, contact information, a brief description of your issue. So if it's a lease cancellation, that would be the issue, and the names of any of those who might be involved. We will then conduct a conflicts check based off of that initial information. And this is something that's required by all lawyers to do. And that's because to be zealous advocates for our clients. And part of that duty also requires us not to take on cases or clients that present conflicts of interest with our other cases and clients. So one example in the homestead kind of context is two co-lessees. There's a bitter disagreement between them. An attorney cannot represent both of them because their goals are directly adverse or opposite of one another. Another example may be in representing one of those co-lessees. The other seeks representation in a completely different case. Although it's not directly adverse, the attorney might not be able to represent the second co-lessee if it would materially limit the representation for both of them. So once a caller clears our conflicts check, our intake staff will contact them again to fill out an e-form to provide more information about their issue. If you don't have an email address or internet access, then our intake staff will contact you by phone to fill out that information. Then once we have that information, NHLC's small but mighty team of 6 attorneys meet to discuss your inquiry, and an attorney will then follow up with you. And with all of that said, I would like to say a mahalo again for joining us this evening, and we'll now open it up for some questions. So please use the Q&A button on the top to submit your questions, or email us at info@nhlchi.org. Or if you have a specific question specific to your situation, you're welcome to contact our office to open an inquiry.
Okay, thank you, Henderson and Kawila. So I have a few questions, but anybody who is on the line still and would like to ask them, please continue to send them in either by email or using the Q&A feature. So Henderson, first question about a hearing. If I receive a hearing notice, but I can't attend on that date and time, what should I do?
I think for that case, the person facing or the lessee should contact either the department. They may be represented by one of the deputy attorney generals. So either contact them and let them know, but also let the Hawaiian Homes Commission, specifically the secretary, know so that they can let the hearing officer know. The hearing officer may then change the hearing date to something that works out for them.
Okay. Where are contested case hearings held? Are they virtual or are they in person?
They can be either one. As I mentioned earlier, it really depends on what the hearing officer wants to do. So it could be in person, and if it is in person, it's on the lessee's island, and it could be over Zoom.
Okay. Can I avoid cancellation of my lease after the proceedings have started by transferring my lease to another family member? And I think this came from Kiona on the call. So thank you for the question.
Yeah, that's a really interesting question. And from what I've seen so far is if there's an alleged lease violation, that usually prohibits a lessee from trying to transfer it. And so usually with lease transfers, the department will want to make sure that every term of the lease is being followed. However, I think maybe it really all depends. During the contested case hearing process or the lease cancellation process, the department might agree to that lease transfer, even though there might be existing violations.
Right, and something to note, the lease transfer would have to happen before the lease is canceled.
Yep, exactly.
Again, because of that one case, that Tanaka case, once a lease is canceled, according to that case, if it's still held up, the department could not do anything other than return it back to the, to the inventory of property.
Thank you, Henderson and Kuila. And actually, I got confused from the stream of questions. So that wasn't Kiona's question. Kiona's question was actually this next one. So if a lease is canceled, are eligible relatives given the opportunity to purchase the lease?
Right, again, so that would have to happen before the lease is canceled. Now, I believe, seen the department in cases, and also, I believe, as a message saying that, one way to solve a lease cancellation is to transfer or, sell to a family member. So that may be a possible way to avoid it, but it would have to happen before the lease is canceled, like we mentioned, so long as that case still stands as law. And I think there was another question, if I could jump, about getting a copy to view the administrative rules regarding lease violations. I'm wondering if that's something we can pop into the chat. The only place to get it right now online is from the DHHL's website. Otherwise, to get one in person would have to be through the Lieutenant Governor's office. The website is not always up to date, and that website just sends you to the DHHL website. So I think we're going to drop that link in the chat. I will say the rules are split up, unfortunately. There is no compiled version that's available on the website, so you'll have to look at the original version with, and then there were several amendments that were passed over the years, some quite recently, as to proving blood quantum and DNA testing. But again, those should be available on the website, and we're gonna drop a link in the chat.
Thank you. And I think Sheldon is going to take care of putting the link in the chat.
Okay.
Okay.
One other thing, if I could add one more thing. So in the DHHL's rules, and it's just, they may be split up by titles or subchapters, but you're going to see it it may be over several documents, but it is not going to be set up by like lease cancellation here and wait list there. They're generally compiled into one document, but also there's a statute, HRS Chapter 91, which also applies to lease cancellations. That's just the general laws that are about contested case hearings for all state agencies. And that's something that we can also try and drop a link into the chat.
Okay, this is another question related to what happens if my lease gets canceled. So if a lease is canceled, how long do you have before GHHL expects you to move out?
That's another really good question. And really the answer to that one is kind of a typical lawyer answer in that it depends. My understanding and the times that I've worked with the department on these sorts of issues is that they are understanding of the situation. And so it is possible to work out an agreement on when the lessee is able to move out and avoid that writ of possession we talked about.
I'll say the reason why there could be a range, the minimum is 45 days. So that's all the department is required to give by law. But there's no upper limit if they choose to give more. By the way, the 45 days is by law for any eviction to give notice to end any type of lease, whether it's a Hawaiian homestead lease or any other rental lease. 45 days, after the 45 days, then they can go to court. But more time could be given, more time could be asked for. And again, this is if we're so far, if we're in that mode, well after any challenges to the cancellation has come and gone.
Okay. Here's a question about counsel or getting help from an attorney. What are my options if I'm not able to find an attorney before the hearing, but I want to have an attorney help and represent me? And I think it might be getting at whether or not I can get more time.
Yep. So whether it's court or contested case hearings, the magic words are usually, I'm in the process of hiring an attorney. Whether it's a court or the state, if they don't give you that time, that could be a reason to fight anything bad that happens in your hearing after the fact in an appeal. It's something that is really important. Everyone should have the opportunity to hire an attorney. They should give you an extension. And if they don't, that's something to keep track of. And if you eventually hire an attorney, let them know that they didn't give you extra time.
Okay. Another question, shifting to once you're in the hearing process. So another hearing question. How long do contested case hearings last?
That, it sort of depends. Again, it could be half a day, it could be a couple days, or it might even be weeks. So it depends on the issue being argued and the amount of evidence that both parties want to present.
Okay. Okay.
I'll add to that real quick. That's just for the hearing itself again. The whole process sometimes could take months. So,
Yep.
But just when it comes to your submitting evidence, taking witnesses, making oral arguments, that could be, like Henderson said, half a day to several days or possibly a week or weeks. But the whole process could take some time. And even after the hearing's over, there's follow-up hearings, there's follow-up paperwork that can be filed. It's not over just after, your last witness gets to speak.
Okay. We had a couple more questions and then just wanted to verbally acknowledge Carolyn. I see your hand up. If you're able to submit your question using the Q&A bubble or email, that would be great. But if not, I'll try to get to you before we close. So another question that came through the Q&A. This involves co-lessees, which we talked about quite a bit actually in our successorship webinar a couple of weeks ago. But I'm now realizing we didn't really talk about in the context of lease cancellation. So there's kind of two questions related to this. So I'll start with one and then I'll have a second one behind it. So what happens if you're in a co-lessee situation and the lease violation is because of one of the co-lessees' actions and not the other? Do both lessees risk losing the lease, or would it just be the one co-lessee that has created the lease violation that would have to face that possible outcome?
You know, that's a really difficult question to answer because the law just isn't clear. I think there are limits in who can ask for a lease cancellation. Generally, if there's a dispute among co-lessees, one cannot force the other out. But, each co-lessee has their own obligations. They have their own lease obligations. And there could be an argument that could be made that if one is following, the other is not, that the one who is following should not be punished. Again, it's not clear. It would be difficult to give you a black and white answer because the law just doesn't say it.
Got it. Maybe depends on the circumstances.
Mhm.
Yeah. Okay. That's a really good question, though. Thank you to the person who asked it, because we prepped for this and I don't think any of us even thought to touch on the co-lessee issues, but those are really good questions.
For that lessee issue, though, I just want to say that we do talk about some of the considerations for co-lessees or lessees if they're naming multiple successors who will be co-lessees in our first webinar. So we do have some information on that. And that's just something for lessees to think about going forward for their successors.
Yeah, I think it kind of highlights what can be a challenge when you have co-lessees. So it's a good flag. And we did talk about that in the prior webinar that's already on YouTube if folks want to check that out. Okay, so this is kind of related to the question I just had, though, on the co-lessee situation where one co-lessee is responsible for a lease violation and the other is not. So a little bit of a twist is, what if it's the co-lessee who's not causing the violation that actually wants to report the violation? And I feel like, I guess one thing just based on what you said is, does making that complaint actually risk the whole lease being canceled? That's what I think you basically have flagged with your answer to the prior question, is that in that situation, that would be one of the concerns.
So that question actually brings up a couple of issues. First, at times, DHHL will not get involved in, disputes among people who are residing at a homestead lease. For example, let's just have a situation where a lessee is trying to evict someone. If that person does not have a lease, DHHL will not get involved. If we're talking about someone would like to report a lease violation, my understanding is enforcement division is who's normally contacted, and they are the ones who are supposed to investigate any lease violations. I think Makalika really put a pin in the issue, though, is just be aware that may bring up a very contentious proceeding between lessees, which may require going to a contested case hearing. But not to say not to do it, just be aware of, if the department may start this hearing for both owners.
Okay, that's helpful. So we are, I think the only question that I haven't asked yet that has been submitted, and Sheldon, who's our backstage operations helper, if you have any that I've missed, please go ahead and come off mute and let me know, because I don't want to miss any. But I think we've gotten through the ones that came through the Q&A and through email. Carolyn, I see you have had your hand up this whole time, and so I don't want to cut you off. So we have, though, because of privacy reasons, really been trying to not have people come off, and we're going to record this. So one idea to Carolyn and anybody else who's got their hand not up but wants to ask a question is please call our office. It really is not hard to reach us. We are at the office Monday through Friday, 8 to 5. Or I think actually 4:30 is when we stop having reception for our calls. But you can call us anytime. You can also email us offline. And we really welcome the opportunity to answer your questions. And actually, one of the things we're really proud of at NHLC is if someone calls and asks a question about Native Hawaiian rights, as long as we don't have a conflict helping you, you get to talk to a lawyer. So please, and it's very rare that a legal organization makes that commitment, but that's our commitment and we're very proud of it and we really welcome your calls. So, I mean, we're closed for the holiday tomorrow, but we're open again on Monday. So with that, Kawila Henderson, do you have any final closing thoughts before we end the session?
Yeah, one thing that I want to say is we've said it a couple times, but a contested case hearing, it is possible for a lessee to sort of navigate it on their own. But my personal recommendation would be to contact an attorney because of some of the complexities that might come up. Some of these deadlines and all these administrative rules that the lessee would need to navigate. Having an attorney would be able to help navigate through those issues and make sure that these important deadlines, such as the deadline to appeal, isn't missed.
That's great. I would add that what we talked about today is the process as it is now, you know, how the law sets it up. But that law can change. DHHL's administrative rules can change. And I think we talked about a lot of issues that do need changing or could change or could be better. And there are definitely brighter minds on this call with us than myself who can come up with these solutions that are holistic, that are community-based, that are understanding and empathic, that are easy to navigate and not costly. The law can be changed. So on one hand, this is how to navigate it as it is now. But I do hope that as continue to move forward, that is something that will be advocated for and fought for and will be changed to make this process a better one.
Thank you so much. I think my last closing comment, maybe reinforcing something that I think you mentioned earlier, but Henderson, when you think about calling NHLC for help, one question that often comes up is, how much does it cost? When people think about lawyers, often what their concern is if their ability to pay and the expense of it. So at NHLC, one thing I'd like everyone to know called is we're a nonprofit law firm. We are very grateful to have grant support, especially for folks who qualify as indigent. So what that means is, you know, we've got funds, especially for people who are, you know, meet the income qualifications where they don't have the means to pay. We do not believe that should be a barrier to receiving the counsel you need in these kinds of matters. And for folks that have means, even within that guidelines, we have a sliding scale fee schedule. And so the bottom line is we work with our clients and we don't ever want the cost of the legal service to be the reason that you feel like you don't have access to the representation that you need. So please call us. We really welcome the chance to help if we can. So with that, I will say mahalo again to everyone. Mahalo to Kawila and Henderson for sharing all of this information. And I hope everyone has a great night and a safe and happy holiday weekend.
Hello, everybody.
Aloha.